For years, politicians promised that limiting your magazines would make you safer. They told you 10 rounds was enough. They told you no one needed more. And in California, they went further than almost any other state, banning standard capacity magazines and threatening millions of law-abiding citizens with fines and felonies. But now, in a stunning turn of events, the Ninth Circuit Court of Appeals, long considered one of the most hostile courts to gun rights, has issued a decision that could end magazine bans nationwide. Yes, you heard that right. What started as a California case, Duncan versus Bonta, has turned into a showdown with implications far beyond one state. If the logic of this ruling holds, then the laws that restrict what you can carry in your firearm may collapse coast to coast. This isn't just legal theory, it's happening now. It's real, and it could reshape how Americans exercise their Second Amendment rights in ways we haven't seen in generations. Welcome to Firearms Law Advisor, not politics, not spin, just the raw truth about the legal battles shaping your future. Stay ahead of the fight. Like this video and subscribe now. So in this video, we'll break down how California's ban sparked a constitutional battle, why the courts are finally siding with gun owners, how this case could set a precedent that erases bans in every state, and what this means for you, your family, and your rights. Because this isn't the end of the fight, it's just the beginning. Chapter 1: California's War on Magazines. California has long been the testing ground for strict gun laws. In 2000, lawmakers passed a law banning the purchase, sale, or importation of magazines holding more than 10 rounds at first. Possession of existing magazines wasn't banned. By 2016, lawmakers escalated, criminalizing simple possession. Result: millions of law-abiding citizens suddenly face the choice of surrendering property, destroying it, or risking penalties. But here's the truth. Standard capacity magazines are not exotic military gear. They are the default for America's most common firearms. Glock 1717 rounds, AR 1530 rounds. Most modern pistols between 12 to 19 rounds. Calling them high capacity was a political trick, not a reflection of reality. Chapter 2: How Freedom Week Shook the State. In 2019, Judge Roger Benitez of the Southern District of California issued a landmark ruling. California's magazine ban was unconstitutional. His opinion was unapologetic. Banning magazines in common use violates the Second Amendment. The result was Freedom Week, a one-week window where Californians could buy, sell, and import standard magazines. The response was massive. Gun shops sold out in hours. Online retailers shipped tens of thousands of magazines. Estimates suggest over 1 million magazines entered California during that short window. And the most important fact, crime didn't skyrocket. Chaos didn't erupt. Freedom Week showed that ordinary citizens simply wanted access to equipment. The rest of America already owned Chapter 3 brewing and the death of balancing tests. The real turning point came in 2022 with the brewing decision from the Supreme Court. Before brewing, courts used balancing tests. States argued public safety justified restrictions. Judges usually upheld the laws after brewing. The court imposed a new test text: history and tradition. If a law isn't rooted in the Second Amendment's original meaning or historical precedent, it fails. No more safety excuses. And when you apply that test honestly, magazine bans collapse. There is no history of limiting ammunition capacity. The founders wanted citizens armed with effective weapons. The principle was clear: the people should not be outgunned. Chapter 4: Duncan versus Bonta, a landmark victory with Bruin as the backdrop. Duncan versus Bonta returned to the Ninth Circuit. Plaintiffs argued that California's ban could not survive under the new standard. The Ninth Circuit shocked the nation. They struck down the ban. They admitted magazines in common use are protected arms. They recognized that the state's arguments about safety didn't hold under the new rule. This wasn't just another legal skirmish. It was the first major to a win in the Ninth Circuit. If even this court couldn't uphold California's law, the writing was on the wall for similar bans across the country. Chapter 5: Why magazines are about survival, not preference. Gun control advocates love to frame magazine capacity as a matter of preference. They argue no one needs more than 10 rounds, but that framing is misleading and dangerous. Here's the reality. Multiple threats are common. Defensive gun uses often involve more than one attacker. Carjackings, home invasions, gang activity. These aren't one-on-one encounters. 10 rounds can be gone in seconds. Police don't limit themselves. Law enforcement officers routinely carry firearms with 15 to 17 rounds and often spare magazines on their belts. If 10 rounds were enough, why wouldn't the state hold its own officers to the same limit? Stress drastically reduces accuracy. Even well-trained shooters miss under pressure in a real gunfight. Accuracy rates can drop below 25%. That means needing more rounds to stop a threat, not fewer. Consider the math. If you face 3 attackers and your accuracy drops under stress, 10 rounds won't cut it. Reloading in the middle of a life or death encounter isn't just difficult, it could be fatal. Magazines are not accessories. They are the lifeblood of modern firearms. Restricting them doesn't inconvenience criminals. It handicaps law-abiding citizens who are already at a disadvantage. That's why courts in Duncan versus Bonta recognize that magazines aren't about luxury or what's nice to have. They're about what's necessary to survive. Chapter 6. Real-World Lessons. Houston home invasion theory is one thing. Reality is another. And the Houston home invasion makes the point crystal clear. A man asleep in his home was startled awake by 4 armed intruders kicking down his door. Imagine that moment. Dark, chaotic, adrenaline surging. He grabbed his firearm, equipped with a standard capacity magazine, and opened fire to protect himself. He fired more than 10 rounds in that encounter. If he had been forced to rely on California's 10-round standard, he would have been forced to reload under attack. That pause, even 2 or 3 seconds, could have cost him his life. This isn't a one-off case. Across the United States, defensive gun uses frequently involve multiple attackers working together, high-stress environments where accuracy drops, limited time windows where reloading is not an option. Survivors of home invasions and carjackings often say the same thing afterward. I didn't count the rounds. I just kept firing until the threat was gone. That's why arbitrary limits are not just impractical, they're deadly. Lawmakers can argue numbers in hearings, but the person fighting for their life doesn't care about statistics. They care about survival. Duncan versus Bonta isn't just a court case. It's recognition of a fundamental truth. The state should not decide how many chances you get to save your life. Chapter 7. California's Counterattack. Death by 1,000 Rules. California wasn't ready to surrender after Duncan versus Bonta. When the court struck down their magazine ban, state lawmakers immediately launched a counterattack. Their strategy was clear. If they couldn't ban magazines outright, they would bury gun owners under endless new restrictions, declaring more and more sensitive places where carrying is banned from public parks to entire city blocks. Proposing mandatory liability insurance before citizens can exercise their rights, expanding training requirements, paperwork, and renewal fees that turn a right into a privilege. Passing emergency laws designed to slow down or confuse gun owners, even while lawsuits move forward. This is what many call death by 1,000 cuts. California knows its bans won't survive under the Bruin test, but they're betting that frustration, cost, and fear will achieve the same result. The problem for them? History isn't on their side. There is no precedent for banning carry across entire cities or demanding citizens buy insurance to own a firearm. That's why these new schemes are already facing lawsuits, and why the courts may soon strike them down, just as they did. The magazine ban, Chapter 8. The domino effect. In other states, California may have been first, but Duncan versus Bonta is already shaking the ground under other states with similar bans. Once one court strikes down a law, others are forced to re-examine their own. Because precedent is contagious. A single victory can start a chain reaction that sweeps across the nation. New York's SAFE Act long one of the strictest gun control packages. It includes a 10-round magazine cap. Now, lawsuits are using Duncan as a direct precedent, arguing New York's law cannot survive under Bruin's text. History and tradition test. New Jersey's 10-round cap, a cornerstone of its restrictions, is now in jeopardy. Challenges cite both Bruin and Duncan, pointing out that there's no historical precedent for capacity limits. Hawaii's magazine laws as part of the Ninth Circuit. Hawaii is in Duncan's direct shadow if California's ban fell. Hawaii could be next without even needing a new trial. Illinois bans. Illinois recently passed sweeping restrictions on rifles and magazines. Plaintiffs are already leveraging Duncan, using its reasoning as a weapon against those laws. This matters because once courts in multiple states start striking down bans, it creates momentum that higher courts, even the Supreme Court, cannot ignore. And when the High Court affirms the standard, it becomes the law of the land. What started in California is no longer just a state fight. It's becoming a national domino effect, where one victory sparks another, until the entire system of magazine bans comes crashing down. Chapter 9. Political shockwaves in Washington, D.C. The courtroom battle may be over for now, but Duncan versus Bonta has already spilled into politics. In Washington, the ruling is being used as fuel by both sides of the Second Amendment debate. Gun control advocates like Chris Murphy and Chuck Schumer warn that striking down magazine bans will make America less safe and are pushing new bills to replace the old ones. Pro-2 organizations such as GOA, FPC, and SAF celebrate Duncan as a milestone victory, calling it proof that courts are finally respecting the Constitution. The White House finds itself cornered, publicly denouncing Duncan, but privately aware that another Supreme Court case could deal them an even bigger loss. Election strategists already see Duncan shaping the 2026 elections, with candidates forced to take clear positions on magazine bans and the Second Amendment. Duncan is no longer just a legal decision. It's a political earthquake, one that could shift the national conversation on gun rights for years to come. Chapter 10. What gun owners must do now. Duncan is a massive win, but it's not a reason for gun owners to sit back. Victories can be rolled back if citizens don't stay active and engaged. Stay informed about lawsuits in your state because laws are shifting quickly. Know your rights under the Duncan precedent and avoid falling into legal traps. Support the fight by backing the organizations funding these expensive lawsuits. Stay politically active so lawmakers can't pass new restrictions disguised as safety measures. Educate others by sharing accurate information so misinformation doesn't spread. The ruling proves that persistence works, but it also reminds us that the opposition never quits. The future of the Second Amendment depends on citizens who remain vigilant and ready to push back. Chapter 11. A constitutional turning point. History remembers the cases that changed the course of rights in America. Duncan versus Bonta now stands alongside other landmark Second Amendment rulings. Heller, 2008, confirmed the individual right to own firearms. McDonald, 2010, applied that right to the states. Bruin, 2022, confirmed the right to carry outside the home. Duncan versus Bonta, 2025, secured the right to own standard capacity magazines as protected arms. This isn't just about hardware. It's about whether the government can chip away at the tools that make rights real. Duncan's answer is clear. The Second Amendment protects what Americans actually use, not what politicians think is enough. Chapter 12. The end of mag bans, or just the beginning? So is this the final chapter for magazine bans, or the first chapter in a much larger war over the Second Amendment? Magazine bans are falling, but states are already creating new loopholes and roadblocks.